Thank you so much, Sarah. It's a real pleasure to be here. And I wanted, before I begin, to really thank the HPG team. Of course, Sarah, also Wendy and Toril for your leadership in putting this event together. And I had to say that it really was Sarah's, I think, foresight in recognizing that there was a tremendous amount of research on this topic and many papers, including by us, going 50, 60 pages. But the recognition that as the issue became more complex, we really needed something accessible that could summarize the key challenges. So I really want to acknowledge that this would not have happened if it wasn't for you, Sarah. And then finally, just to recognize that our colleague Jessica Bernisky, who is a consultant who works with us on these issues from time to time, played a real key role in drafting the document, as well as Dr. Olivier Bangerter, I wanted to recognize, played a role in encouraging us to create this document. So I think the way we're going to do the slides is that I will unfortunately have to say slide. So my apologies in advance, but I think that's the way we'll forward the slides. We can go to the next one now. I just very briefly wanted to say, despite the alluring title of this document, What Aid Agencies Need to Know, and despite the fact that we are sitting at the Harvard Law School, this is, of course, not legal advice, and we would never purport to tell any individual aid worker or agency how we think they should face these challenges. Rather, our goal in the network paper and in Dustin's presentation is to highlight what we think are some of the questions you might want to ask as you face these complex legal and policy issues. Next slide, and we can go directly to the one after. Thanks. So what I want to do in my brief time here is just to lay out very quickly what we see as the tension that informs how counterterrorism laws and policies around the world may and do affect humanitarian action, and then to lay out some of the challenges that we identify in the network paper as being those that over the years that we've been working on this topic, we have seen as sort of rising to the top as being the most crucial, or the ones that humanitarian actors seem to perceive as being the most problematic or the most troubling in their work. The way I tend to think of this issue and the way I tend to myself conceive of it when I approach new legal dilemmas is that we have two trajectories, two policies and laws, if you will, that for a long time developed independently of one another. So one is that which most of us in the humanitarian field are far more familiar with, which is the series of laws and policies, Security Council resolutions, General Assembly resolutions, that particularly in the last 15 years have emphasized the importance of meaningful humanitarian access, have built upon the foundation of international humanitarian law by insisting that real humanitarian action includes engagement with non-state armed groups and engagement with all parties to the armed conflict to ensure access can be sustained. The other trend, which I think many of us working in this field perhaps were not so aware of until recently, is the development in the arena of counterterrorism law and policy to increasingly, particularly post 9/11, restrict and regulate any flow of resources, intentional but also unintentional, to listed terrorist organizations. And this process includes not only creating criminal laws, but also sanctions and regulatory policies that seek to limit the provision of resources to terrorist groups. Next slide, please. So one sort of norm or trajectory seems to be very much built on the notion that we have in humanitarian law of the right of initiative, the importance of humanitarian actors being able to engage all parties to conflict. Next slide, please. And the second one seems to be rooted very much in the post 9/11 Security Council resolutions, particularly 1373 and 1267, that emphasize the obligation of every state to create and enforce domestic counterterrorism laws that criminalize the provision of support to terrorists and create domestic legal and policy mechanisms for restricting the flow of resources to terrorists. Next slide, please. I'll get into in a minute sort of how we see this becoming a real life problem for humanitarian actors, but just very briefly, these are sort of the kinds of places where we see these issues intersecting or becoming sort of a space where both this counterterrorism trend and this trend in humanitarian policy can be seen as coming together. And the way I see the real life tension between these two trajectories is particularly in situations of armed conflict where a party to the armed conflict is also listed as a terrorist organization. If that group either controls physical access to civilians or controls areas in which humanitarian crises may occur or be worsening, that is where we tend to see the humanitarian principles and IHL protections for humanitarian access coming into possible tension with counterterrorism laws and policies that wish to regulate those same groups seen as terrorist organizations. Next slide, please. In the paper, what we seek to do is to highlight those aspects of humanitarian action that may come into contact with these counterterrorism laws and to identify the key challenges and questions that we see arising there. Next slide, please. Thank you. So as I said, the counterterrorism regulations that we look at focus on Security Council laws, policies emanating from global counterterrorism bodies such as the FATF and the Global Counterterrorism Forum. Next slide, please. And also looking at domestic and regional counterterrorism regulations. So we've seen a real growth in criminal laws that lay out the ways in which an individual or a group could be criminally liable for providing support to a terrorist organization. What's important to note here for humanitarian organizations is that very few of these laws include an exception or an exemption for humanitarian action. They tend to be very broadly worded, and they tend to have different criteria for intent to provide support, but one that sees any kind of support as being criminal. Next slide, please. So how can this really come to pass in reality? Many of us have indicated that there are many legal ways in which you could see, for example, provision of medical assistance to wounded fighters is protected in IHL, but provision of medical assistance to listed terrorists is a crime in many donor jurisdictions. Well, that may be just an abstract conflict, right? A legal one that we see on paper. How can it really affect humanitarian organizations? Well, one way that we've seen in our research is that donors, particularly the largest donors, those that tend to fund both major UN humanitarian organizations and NGOs, can increase their scrutiny and their restrictions and regulations on humanitarian organizations in light of these growing counterterrorism laws and policies. Dustin will be spending most of his time talking about this issue, and for us, it's really come through as one of the most significant challenges affecting perhaps the largest number of organizations. Second, counterterrorism laws could be interpreted to cover what we might call incidental diversions or transactions. So here what we mean is, let's say you are an organization working in an area where a listed terrorist organization that also happens to be a party to an armed conflict controls actual territory. So Al-Shabaab in southern and central Somalia for many parts of the last 5 years, AQAP in parts of Yemen, Hamas in the Gaza Strip, and of course, increasingly ISIS in both Syria and Iraq, with addition, of course, of many armed groups in Syria on the border, in particular with Turkey. If you are conducting humanitarian action in those areas, and for example, an armed group requests a tax at a checkpoint, maybe a very nominal one, $25, $150, $200, or you are engaging in warehousing of supplies in order to prepare for a convoy, and you come to realize that the local businesses are connected with members of the armed group, not in a bribery scheme or anything like that, but they are connected through clan, family, or other networks with the armed group. One of the concerns may be that this checkpoint fee or this tax or registration that you are providing, while it would be accepted if you were providing it to the state and perhaps even to a regular armed group, it could be both criminal and legally sanctioned through civil laws if provided to a listed group. Finally, we've seen that there are real concerns about the additional burdens and risks that are created to humanitarian organizations in the field. So one of the ways in which we've seen this become very real for humanitarian actors is requests for increased vetting. That donors may be telling humanitarian organizations, if you are going to work in this high risk area, we need to know very thorough, very digging deep into the details of information about individual partner organizations and even in some cases, beneficiaries. Next slide, please. One of the things we talk about in the network paper is how might these possible areas of intersection and interaction really create challenges for humanitarian actors. We've certainly seen the rise, I think, of concerns around sanctions and financial regulations emanating from counterterrorism laws, including increased difficulties in banking and financial transactions related to humanitarian action in areas where humanitarian organizations need to send funds, right? Where they need to be able to pay for the work that they are doing and for their staff. Secondly, one thing we've noticed in both our research and in our engagement with donors and humanitarian actors on this issue is a real challenge in open dialogue. The things we are talking about here are in some ways only possible because there's been years of groundwork by HPG and by others to bring this topic to the fore. But we still find that when it comes down to the real details and the real challenges humanitarian actors are facing in terms of counterterrorism regulation, it is still seen as highly sensitive to ask questions, to seek to clarify the legal regulations, and to seek to understand exactly what are the limitations that may be imposed on humanitarian activities in a particular high-risk area. Next slide, please. I want to hand it over to Dustin, but I want to indicate in particular one area where we've seen I think an increased sense of concern in the part of the humanitarian community, and that is the question of reputational harm. What happens not if you are prosecuted, which we've seen very, very little of around the world, not if you are investigated by a charity commission or other body as a formal matter, but rather if a lobbying organization or a national newspaper suddenly puts forward an article either on the internet or in print stating that your humanitarian organization has been providing taxes to a terrorist group. How do we think through these kinds of risks that are perhaps extra legal, not necessarily linked to prosecution or legal process, but from the law and from the restrictions in the law actually leading to reputational and possibly funding related harm and the capacity to act in areas where affected communities have real needs. I want to turn it over to my colleague Dustin, and I'll set him up by saying this. I think of all of the challenges that we heard in our research for this network paper and in our broader work with our working group, the issue of counterterrorism clauses in donor contracts, in agreements of funding to from donors to humanitarian actors, has come to the fore as perhaps the one that we hear about the most. How do humanitarian organizations deal with grants that incorporate vague, broad counterterrorism restrictions into their language? And what Dustin will do is sort of talk about what do aid organizations need to know when they think about that specific challenge. Dustin?